you are serving a very key role in moving cargo as transportation professionals. And if you fail to perform in a certain way, or you do perform but in an improper or non-compliant way, of course, there could be risks. And you could come under scrutiny whether you're a customs broker, freight forwarder, NVOCC, property broker, warehouse operator, cargo screener, an indirect air carrier, or even a 3PL. So probably you're here today because you provide those types of services. What's the risk? The risk I always ask when a company comes to me, well, what's the damage? If you did something wrong or you didn't perform your services properly in moving the cargo, or arranging for the delivery or transfer or handling or store of the cargo, is the potential loss, and even more so the actual loss of the party as a result of your performance or lack of performance. So really, the risk comes down to what are those potential damages or actual damages as the result of what you did. And today, we will be discussing, of course, how you could limit that risk, and you could cap that risk amount of money, the amount of dollars that potentially could come out of your pocket to make that party whole. That's what it is about at the end of the day. Karen, what do you see as risk from your standpoint in the insurance world?
Well, talk a little bit about the policy itself and what it does. It defends you foremost when you're being held legally liable for a loss. One important reasons why you want an policy and we want to purchase that policy is because it's a payment of legal fees. Those costs can often be very high and more than you're willing to absorb as a company. That's important to note because I think some people think, well, I'll just hire my own attorney. Well, that's fine, except that when you have a very large loss, those fees tend to get really high, really fast. So the insurance pays for legal defense and the settlement that is awarded. And a lot of the claims don't have any merit. I say this all the time, but somebody needs to defend you. So you might say, well, I'm not even liable. Why am I even in this lawsuit? Well, that's when the policy steps in. It will defend you under those circumstances. Oftentimes it doesn't make sense, but you have a policy to protect you. So these offer first dollar defense, so those legal fees would be paid $1, and it lists the unexpected costs. So, we're going to take a look at this presentation. We see often. Those include misdelivery of cargo, improper release of goods, negative selection of carrier, and classification of goods. This is not an all-inclusive list, of course, but these are typical claims that we see. Let's look at misdelivery of cargo. In a particular situation, the goods were subsequently lost by Brazilian customs when they were improperly labeled by the freight consolidator. Once the goods were located, the buyer said, I don't want these anymore. What do I do now? I'm blaming you because you improperly labeled these and they were shipped to Brazil when they should not have. Once goods are seized in Brazil, it's oftentimes very difficult, if not impossible, to get it back. And sometimes the cost of goods is less than the amount that you would have to pay to get them returned. Sometimes it just doesn't make sense to try them out of there. In this particular case, the sum is $40,000, and the legal fees, which were paid on a first dollar defense basis, were $7,000. The insurance company can altogether $4,000 after the freight forwarder's deductible of $5,000. I think risk management considerations of a misdelivery.
Well, first I'll add, I think it's great that in the misdelivery example, there was only a few $1,000s really out of pocket from the parties who were involved in this delivery. That's going to see leads like that. I'll be the first one to vouch for that. And in a case like this, well, again, various risks when you're involved in transporting and moving cargo, and in this case, misdelivering it because of the fact that there was wrongfulling on the cargo. When you surrender title to or possession of cargo without receiving the original shipping documents, particularly a bill of lading from the receiving party, the consignee who intended to receive and purchase that cargo, there's always a risk. And we see this happen quite often, unfortunately, that sometimes, if you will, maybe a company jumps the gun, or maybe there's some error where it went to the wrong party. And you have to be very careful to make sure that, consistent with the bill of lading and the shipping documents, not only goes to the right place, but it goes to the right party, and I'd add under pretty much a reasonable time frame. There's quite a few risks that could lead towards a misdelivery of cargo. And when you have a bill of lading, a negotiable bill of lading to order bill of lading, you are surrendering at the time of delivery proof of payment by the consignee to the shipper. Basically, that bill of lading, as you surrender it, is indicating that there was proof of payment by the receiving or purchasing party to shipping or the selling party. So really, that means quite a bit. That says a lot when the cargo is moving, when the shipping documents are proceeding, indicating that goods are paid for and goods are going to the right party. So as a result, if the shipper, if the seller is not paid, they're going to look to that intermediary, and they're going to say, hey, whether you're an NVOCC in the vessel environment, or if you're an air freight forwarder, or a truck, or a warehouse, and what's the damage going to be here? It's going to be the value of those goods that never made it, because here you have a party that shipped goods, and they get paid for it. So they're going to turn to you and say, I'm out of the goods. I don't have a way of getting them back or being reimbursed for it. Pay me for the goods as the intermediary. So the liability, depending on the value of the goods, could run really high. But for having that E&O, that really provides you, as I sometimes say, your life preserver. That's what a lot of this is about. Make sure you have that life preserver there so that you're not technically underwater for the full price of the goods. Karen, you.
Plenty. I have another claim example, wrongful release. In this case, it was a shipment of whey powder from the United States to Pakistan, and the insured prepared the shipping documentation in the name of the buyer as the of the goods. The goods were released to the buyer prior to release of payment, as Lenny was just talking about. In this particular case, the claimant signed a power of attorney limiting insured's liability to $50. That's important. The power of attorney is an important document. We'll talk a little bit more about that and those and documents and terms and conditions of service and carriage later in the presentation. The reported loss amount in this case was $65,000. And the resolution is that the court enforced that $50 limitation of liability. This forces the reason why you should be incorporating your terms and conditions of service into power of attorneys and referencing them in your signature lines and in quotes. We'll talk about that a little bit further in the presentation. Lenny, speak to this just a little bit further.
Yeah, or enough, the importance of really looking at those limitations of liability in your terms and conditions, syncing them up, so to speak, to your powers of attorney. Your invoices need to be out there. And by out there, I mean they need to be visible. They need to be understood. This is how you first build that business relationship, that you have to have a meeting of the minds, so to speak, that there is a cap, there is a limitation of liability. When you look at the law, when it comes to these concepts of wrongful release, you have the Carriage of Goods by Sea Act, the COGSA, and the vessel environment, and there is a limitation of liability that's recognized not only for those, if you will, acts of malfeasance, negligence, but if there is cargo damage, because sometimes cargo damage can occur as well as a result. And again, you're going to be facing a potential claim for the value of that cargo. And you have to be very careful what jurisdiction you're in, because Chinese courts would consider all BLs negotiable, meaning there's really not a limitation. So again, having that type of potentially agreement so that there is a limitation of liability, hopefully win the day. And we've been involved in quite a few cases over the years, particularly in the United States, where the courts have said as long as there's a meeting of the minds, then we're going to recognize that limitation of liability. So how do you manage these types of risks? Well, really looking at the documentation for transactions, how you set up your customers, making sure that that language is there, they've signed it, they get it, they acknowledge it, and you have that meeting of the minds to begin with, that there's potentially an indemnity against the consignee, the purchaser of the goods, that maybe it should become more of an issue between the shipper and the purchaser or consignee, perhaps through a subrogation or assignment as well from the shipper and paying the claim. Don't worry about those big legal words, indemnity, subrogation, assignment. A lot of you are familiar with them, but the point I like to make about all that is that there typically should be a way for you not to be caught in the middle, that the buyer should be the one who is trying to negotiate this out with the shipper, hopefully, and if one of those parties do get paid and they're made whole, then you should no longer be the target. That there should be that resolution, if you will, if possible, between those parties, especially once they're made whole. But in the meantime, as the intermediary, yes, you're going to be caught in the middle, and we're going to have to make sure that you have that E&O in place and that you have that limitation of liability in place, because some jurisdictions like China, typically they're going to come to the table and say, hey, the BL is negotiable, meaning there's really not a limitation as to what those dashes would be. So you have to show, on the other hand, that he's contracted to and agreed to that limitation.
All right, we'll take a look at a couple other types of claims that we see often. This is one, negligent selection of a carrier. In particular situation, the cargo was loaded on the truck without being manifested and without customs documentation. So the cargo was detained by customs officials. The claimant's attorney filed a demand for payment for $110,000 for the cargo that they ordered because they couldn't retrieve it back from South American Customs due to the fact that it wasn't manifested on the truck that carried the cargo. The insurance company appointed counsel who successfully argued the client acted as a shipper's agent only, and pursuant to their signed terms and conditions, they're not liable for those actions of third parties. The report cost amount here was $110,000, so the exposure was pretty high, and the legal fees were $20,000 to show why they weren't liable. And again, this is another example of terms and conditions and the enforcement of those terms and conditions. And most standard terms and conditions of service include a clause, that says something along the lines of you're not liable for the selection of third parties. To quote that in declinations of liability, when we're working with a client, we'll say you should reference that right back to your customer immediately so that they're aware of that which they acknowledged and signed at the time that you were agreeing to the terms. So that's pretty important. We'll speak to the risk management considerations of this particular type of claim.
Sure, and so here, as it was indicated, again, you see the potential for the loss, $110,000 in cargo, and luckily they were able to engage counsel through E&O and take a step away from the claim and have the liability that typically you would expect them to incur, because they argued that they were a shipping agent only based on their terms and conditions. And as Karen was saying, so important to make sure it's clear in your terms and conditions and the services you are providing. And a lot of times a company comes to me and says, what am I liable for in this transaction? And say, what do you represent doing for that company? If I was to look at an invoice for your services, does it show that you actually are arranging for the transportation, providing the transportation? Are you not necessarily putting your client under that impression? You're you're not collecting fees. It's not part of your business. So the way it's conveyed, the way it's presented as to what services you are providing, the expectation you are setting is critical. So when it comes to negligent selection of carrier, as you could see in this example, yes, it could convert to cargo liability in the worst case scenario. And typically what we see here is a lack of reasonable care in selecting a motor carrier. So although you might not have presented yourself or your company as moving the cargo itself, if we will arrange, we will select carrier, and you're agreeing to provide service, you have a standard of care to which you must adhere to. It's called the reasonable care standard, and if you're reasonable, then that means negligent, and then that opens door to these types of claims. Why don't we go on to the next example, Karen, and we'll talk about it further.
Yeah, to echo something that you said, and it's really important that how you invoice for your services is really important. It needs to match exactly with the type of service that you're actually performing. Their negligent selection case. This was, you can see from the reported loss amount, there's a high dollar claim. So we're looking at $1.3 million worth of shipment of watches that were stolen while the cargo was with the trucker that had been appointed by a truck broker. The cargo had been brokered several times, and the plaintiffs alleged that there was negligent selection of the trucker who then brokered the load. They also allegedly failed to secure the proper insurance and failed to notify all parties special requirements for this high-value cargo. And in this case, no terms and conditions of service were issued. So it was a difficult case. I mean, there were several allegations in the lawsuit, but the main allegation was that negligent selection. It's important to properly vet truckers and brokers when you're arranging transportation. Doing so, will help to strengthen the defense of the case. I'll think about that in the next claim next slide. But in this case, the settlement was a policy limits of $250,000. I want to stop there for 1 second and talk about the policy limit, because if you know you're working with a client who's transporting cargo that is in excess of your limit, you're exposed to the amount of money. So it's important to consider that when you're choosing an insurance policy. Here, the fees were $64,000. We did get the property broker to contribute $10,000 towards the settlement. The overall insurance company payment was $304,000. So, the reported loss amount was very high. The insurance company was successful in settling it within the limit for the legal fees.
I could see why this was a tough one, and I'm glad at least it got resolved the way it did. Because see what happens when you don't have those term conditions in place and things get a little bit dicey, as they did in this case. So here we saw the legal provisions kicking in again for those cargo issues. Are you serving as a motor carrier? Are you arranging for interstate truck transportation? And again, that bill of lading being so critical. If you're issuing a bill of lading, it's very hard to say that you're not involved in the transportation process as a motor carrier, or at least arranging for the transportation. So a lot of times I do ask intermediaries I work with, are you or are you not issuing a bill of lading? What kinds of documents are you issuing that relate to the transportation and movement of the cargo? Because that is going to translate to Carmack liability, which is basically the remedy that's used for the loss of goods transported by motor carriers and freight forwarders in interstate commerce. Again, if you're holding yourself out to the public to provide transportation of property for type of compensation as you ordinarily do, then this is going to apply to you, absolutely. So you have to be very careful about the role you play. And if you, again, issue that bill of lading, there's no way really to argue against the fact that you're transporting and involved in the process. What do you do? How do you manage these types of claims? Well, One, which I think is excellent, and I believe most of you are members of the National Customs Brokers and Freight Forwarders Association. I hope you are. If you go online, you could see their free trucker vetting service, their Trucker Comply Directory. And this is great because what they did is they teamed up with a leading service provider that links forwarders and customs brokers to trucking networks. And basically what it does is it confirms if these truckers, if these motor carriers are properly licensed, are they insured, are they TSA compliant, do they confirm the safety ratings as well, and it provides you with that extra step of due diligence so that you are working with truckers who have been vetted and who are reliable. In addition, above and beyond that, you really have to have a protocol, a process in place as the selection and vetting of the truckers. Is anybody in your company able to pick a trucker here or there, whoever they want? Is there some type of escalation process? If it's a new trucking company that you haven't used before, I would suggest there should be some type of managerial oversight as to how that process works so that you can do the due diligence. Make sure that your contractual provisions are reviewed, that the language between you and the trucking company and, of course, with your customer are very clear as to what those obligations are so that you might not be negligent in choosing that trucker, but maybe that trucker or motor carrier was negligent, so you're off the hook and they're on the hook based on what the standard of care they were supposed to provide. And another piece of advice would be to avoid listing yourself as a motor carrier on the bill of lading if you don't want to get caught in this type of situation, making you don't assume the liability based on the contractual obligations that you set forth. If you're involved with loading a conveyance or increased control or oversight, and that's mentioned in any of your agreements or paperwork, that again is going to rise you to the level of coming under the cargo liability, or I should say negligent selection of carrier cases and issues that could occur. And once again, your marketing, your materials, your website, does it say that this is in your wheelhouse, that you are providing transportation, selecting the transportation? Again, what is the understanding of your customers? All that really is critical when we look at the factors for any one of these given cases.
Okay, let's take a look at a customs case or customs-related case. In a particular situation, a former employee incorrectly classified household good organizers as household good furniture, providing incorrect advice that the goods were duty-free. The correct rate was 3.4%, resulting in increased duties of $160,000, required them to submit a voluntary disclosure to customs. The employee provided this incorrect information during a period when the broker's office was not the supervision and control of a licensed individual broker. That's important because it would have been picked up and realized, and this would have been avoided. Here, the importer filed a prior disclosure tender to the duties plus interest with customs, which they accepted. The broker didn't reimburse the importer for the duties based on the broker's terms and conditions that limited liability to $50 per entry. I mean, this importer would have been responsible for those fees regardless. Yes, maybe it was misclassified, but your policy is defending you from the standpoint of you would have been responsible anyways. And because you have terms and conditions of service that limit liability to $50 per entry, it was upheld here in this particular case. Risk management considerations in this situation?
Absolutely. So my first question, comment is, why does this happen when a former employee is involved, right? There's an employee you had, they did something wrong. In this case, come on, classifying household organizers as household furniture, really missing the mark here. That employee's gone. Maybe the reason why they're gone is they knew they weren't doing things properly, but you're left holding the ball here. And in this case, 3.4% duties, approximately $160,000. So luckily they did disclose it, which is great because that is going to potentially limit your regulatory liability, which we'll talk about a little bit later. And there was a bit of really a happy ending here, I should say, because the terms and conditions kicked in, limiting liability to $50 per entry, which typically has been granted by the courts. Here the risk really is providing any type of false, that's the language in the statute, but I like to say inaccurate, because that's really what it is, information to CBP, because it could lead to rate increases, and then importers, of course, are going to seek the reimbursement. They're going to point the finger at the broker. Now, we all know the importer of record is responsible for proper classification, value, country of origin, if they qualify for a free trade agreement, whatever duties they might owe under the new trade remedies under Section 301 with China and the steel and aluminum, as well as any types of anti-dumping, countervailing duty issues. The importer is in the hot seat, but it's the typical scenario. They will point the finger at the broker. I owe more duties. It's your fault. So CBP is going to collect the duties regardless of who's at fault. They're going to go against the importer of record. They also may issue penalties against any person involved in entering the merchandise with false information. So it might be the importer, it could be a party involved in the transaction if they have a financial interest, especially. We've seen cases about that. It's called the Trek Leather case, where the party wasn't necessarily the importer, but he was very much involved with the information being provided to customs. As a broker, you have a see as to how much customs could come against you if they feel that you were part of the issue and the problem. But what we're talking about here is how much can the customer, the importer, get from you. And luckily, you typically are going to have that limitation of liability in your terms and conditions. And if on to the next slide, we'll talk about it a little more. The law does say that the customs broker terms and conditions should, in fact, relate to those activities that concern customs business and limited to $50 per entry. Again, the courts acknowledged and they have granted that $50 cap per entry, and making sure that that's part and parcel of your terms when you bring on a new customer and you get that language. It's really key. I sometimes have importers and brokers going back and forth because the importer doesn't want to suffer on that provision. I tell the broker you have a very serious decision on your hands because I think you're opening yourself up to quite a bit of exposure if you don't agree to it. So what do you do? From the standpoint of managing all of this, definitely make sure from get-go you try to classify merchandise properly. Make sure that you have the tariff training in place. You have the tools in place, meaning your company, your employees are very familiar with the harmonized tariff schedules and they know where to find them. They're familiar with the CROSS database, which is CBP's database of tariff decisions, but you have your own database for your clients so that there's, again, some type of process in place with the experts, the gurus, if you will, on the HTS, so that everyone in your company pretty much sing off the same sheet of music when it comes to the proper tariffs. And when there's a complex one, and that might have to be escalated to the expert in the house. And that oversight to make sure that these processes and procedures followed day in and day out are so critical if going to limit any type of misclassification claims. The TCs, your terms and conditions, that limitation liability, making sure there's a meeting of the minds is super critical here. And I think also having a good communication flow with your importer is critical. I speak to some importers who say, oh, I don't really review the entries that my broker files for me. Well, I tell them that's your fault. You need to see what your broker's filing to catch any errors. And sometimes they say they don't even get copies of the entries. And as a broker, if you're not sure that your customers are seeing what you're filing so they could correct things or advise you if something has run amok, then I think you are partially opening yourself up to visibility and a lack of visibility in issues as well. So make sure that you communicate with your importers, that you really know what types of commodities and products they're bringing in, and they know what you are filing on their behalf. So that would be my takeaway on the risk management piece from a very common but often seen classification type issue.
And these tools and techniques already, like the importance of, insurance, terms and conditions of service, carrier selection process. You spoke, Lenny, a bit on each of these, actually, about the education and training and where you can, go to make sure truckers are properly vetted, as an example, and HTS training. We'll be doing regulatory defense and the risk review in a few slides, but maybe what you could speak to now is just the terms and conditions in general and those that you see all the time and that everybody encounters every day.
Absolutely. So some of these are just terms, some of these are about terms and conditions, but these are concepts that you should be somewhat familiar with. If it's not a law school class, don't worry, but it really is you all having an understanding of what these key documents mean and words mean. Terms and conditions, you really need to review this document because this is your service contract. This is where we would expect to see your disclaimers, your limitations of liability. Also indemnification, as the fact, are you basically saying you can't be held responsible, you have to be held harmless, notifying the parties that, hey, some of this just can't be your fault. If there's a lien on the goods, for example, and this comes up a lot, is a party able to say, well, I'm going to pay you as the intermediary, as the freight forwarder, as even the broker, until everything is resolved on my shipment? Well, how about on a subsequent shipment or 3 shipments down the road? You can't hold goods hostage, for example, an intermediary because you didn't get paid on a transaction several ago. So these are the kinds of things that should be spelled out in terms and conditions between the parties. The bill, or in general, the bill of lading on the ocean and the ocean environment. This is contract. It's a contract for carriage. It says that there's a receipt of the goods, that there's a pay of the goods. The liability terms are going to be spelled out, as will any type of compensation for loss or damage. So again, making sure that those ocean bills of lading, those airway bills of lading are true to form and that you covered yourself so that there is a ceiling in place. Leaving the contract as well, if there is some type of receipt of the goods, the custody, the consolidation, when it comes to that, you are going to look at your terms and conditions as to your consolidation of the goods, your forwarding. The terms and conditions typically should govern the receipt of the good as well, so that you're covered not only in the movement of it, but also in receipt and delivering the goods. Well, that's a party entrusted with the property. Generally, you wouldn't have a bill of lading. There, we're going to look more towards a reasonable standard of care. We wouldn't expect necessarily for there to be terms and conditions in a bailee situation. But the point I want to make here is that there are legal distinctions between actually holding the cargo as a bailee as opposed to a warehouse or a warehouse proprietor. In a bailee relationship, typically the bailee does not provide a written agreement. We wouldn't expect to see a warehouse receipt or bill of lading. So that's why you're expected to exercise reasonable care. We hope and expect to see as a warehouse proprietor something in writing and have those terms and conditions. So it would be a little bit different. These steps that you're probably familiar with, the Montreal Convention and Warsaw Convention, these basically set forth the liability, the amounts for damages to cargo. So that, of course, is going to be very critical, and we're going to expect to see those in your terms and conditions as well. And for the Carmack Amendment. The Carmack Amendment, as I mentioned before, that's basically the remedy for the loss of goods transported by motor carriers and freight forwarders. It's a type of carrier liability for the loss of goods. again, my question is going to be, are you taking the actual transportation, or are you arranging the transportation, but you have a meeting of the minds that you're not responsible for selecting or being a part of that transportation? Again, long story short, very fact specific as to what role and services are you providing.
Thanks, Len. I want to add just a couple of points there. With regards to terms and conditions, outdated. So the thing I would say, you take something away from this presentation is to go back and look at your terms and conditions and see if they're current. For example, the NCBA updates them somewhat frequently, and you should be using the newest, the latest, the greatest terms and conditions. If you haven't had, and let's say you're not an NCBFA member and you haven't had your terms and conditions of service or carriage or your terms reviewed anytime recently, you should definitely consider doing that to make sure you're current with the times. And the other things that you could do to protect yourself further and to help in defense of a claim would be we reference these terms and conditions. So your terms and conditions of services should be on all of your invoices. A lot of them, the invoices now are issued electronically, so you should have a link to your terms and conditions on electronic invoice itself. If you're still showing them manually, you want to print it on the reverse side. You probably still want to have, I would have the link on the front of it as well to your website. You should include them in your quote, your power of attorney, have signed terms and conditions of service if possible. That's not always possible, but if you reference them in your power of attorney, they're going to be signed by that reference. And you should include a link direct to your terms and conditions of service in your signature line. And I'm correct, not just to the website, but to the terms and conditions of service themselves. Because sometimes I will go on a website and it'll be very difficult to find terms and conditions of service. It's not easy. Eventually maybe I find it, but if you go digging around to try to find it as a customer, it might make it difficult for you to know exactly what those terms and conditions of your services are. Just depending on training and education is, what you do when a claim occurs. Well, definitely don't admit liability. Call your insurance professional and they'll help guide you through the process. So first and foremost, don't admit liability, contact your insurance provider. Lenny, a bit about how litigation costs, how high you see them and what circumstances, and speak to that.
Going through the whole litigation process, although this is just kind of exemplary of why the costs of litigation can skyrocket. Just initiating the case, the investigation, all the research that goes into it, the discovery, the interrogatories, the depositions, trying to settle it. Alternative dispute resolution is ADR. It's mandatory in some cases. Then you have the motions going back and forth, go to trial, the legal research, the preparation, a disposition, that maybe there's an appeal. It's thousands of dollars, if not in the six figures. So most of the time when we a case where there's a really difficult dispute, we really encourage the parties to come to the table, try to settle. Again, having that insurance is going to enable you to do that. There's not necessarily a bar or a prohibition from a claim against another party, but the question is, to what extent what party prevail? And you don't know in most cases unless you go through this whole process. Unfortunately, there's not necessarily a standard that says, sorry, that is a frivolous claim, you can even try to bring it against the party. And the point I'm making is that you're going to have quite a bit of heartache just trying to deal with the case to begin with. Why not try to find a way through E&O insurance where you could bring the parties together with the appropriate legal counsel to avoid all of these steps and a settlement that makes sense. Hopefully, say, cooler heads prevail. That's what this is all about. It's really trying to take it out of the back and the forth with writing up all these motions and spending the legal fees to do that by trying to go to the table and settle it. That's what I really like doing. That's what I did when I worked at the Customs Service. We didn't always take the cases to court. We would try to figure out a settlement that worked for the parties. So that's basically what we're trying to say here, is avoid the tens of thousands, if not way into the six figures, of taking it all to court. It doesn't make sense for parties in most cases to do so. And I think when we look at the next slide, you're going to see some of these costs that just start going up for different types of claims. And you're going to see, although some really more than others, again, they're already in the tens of thousands of dollars when you get to trial, because it all adds up. It's additive, which is going to get you in those tens of thousands of dollars or the six figures. And I don't want to go there. It just doesn't make sense 99 times out of 10, in my opinion.
Yeah, I completely. Regulatory defense. So regulatory defense is a product that goes hand in hand with the E&O policy, and it's a product that's available through Roanoke. Lenny's going to speak a little bit about the program itself in the next few slides and how it would be beneficial to you.
So let's really change gears for a minute. Whereas with E&O, we were speaking towards your customer or a party, a private party coming against you as another private party, as a service provider to the shipper, to consignee, to somebody who was paying you for your services, and unfortunately you did not perform them in the manner that you should have, or they felt you should have. Now we're switching gears, because this is when the government, when quote-unquote Uncle Sam is coming after you. This could be the TSA, the FAA. This could be Department of Commerce. It could be CBP, and they're coming against you saying you are not in compliance with laws and regulations administered by the U.S. government. This has nothing to do, in these cases, in some cases it does, but nothing to do with the movement of the cargo and whether your customer or another party in the transaction feels that there are damages. This is public versus private, government against you. What this does, you're thinking, well, it's going to be at least anywhere from $4,500 to $10,000 to hire an attorney to represent me if the government comes against me with a claim. Regulatory defense for an extremely reasonable amount, or quote-unquote premium you pay each year, provides you with that prepaid consultation and assistance. So that means you sign up for regulatory defense, you pay the annual premium, which is a fraction of what you would have to pay to work with an attorney should a case arise, and that legal counsel will address, as counsel, fine penalties, liquidated damages, if your license potentially might be looked at being suspended or revoked, if there's a letter of investigation that federal agency brings. We'll assess what the allegations are, we'll advise you as to what we think you should do, and if we can't resolve it by conversations with the government and there's an actual claim, we'll respond to the claim. Based on the type of package you have, regulatory defense package that you have procured through Roanoke, then we'll respond to one claim or two claims. We'll always follow up with the claims. I've had my intermediary, broker, forwarder, friends come to me and said, okay, I want to retain you, I have a claim. I said, why are you doing it this way? Go through Roanoke, get the regulatory defense, and you'll get my services at a fraction of the cost. And I've really helped companies save money on their legal fees by encouraging them to get this type of program, this regulatory defense, at a fraction of what they would pay me or another attorney to handle their work.
Yeah, Lenny, it's really a contract that provides benefit to you, and you can purchase an expanded regulatory defense contract. And if you're interested in that, you can contact your local Roanoke representative who can provide you with more information. I was thinking it might be good, Lenny, if you just gave a couple of quick analysis of the regulatory defense program, and so a first example here that you might be able to speak to a little further.
Yeah, I see a few of these, more than a few, come up in the context of TSA. Why? If any of you are involved as an indirect air carrier or CSF, they come after you. They really are looking, and they're asking a lot of questions. And if you're a CCF, are you really screening the cargo? If you're an IAC, is it going to known shippers? I can't tell you the permutation of cases that we've had just settled. One would say regarding the improper use of another IAC certification information. I have another one on my hands where they didn't conduct the screening and they didn't have regulatory defense. So unfortunately, they're going to pay a lot more out of pocket than they would have. In this case, for example, this was an IAC or forwarding agent who tendered inbound cargo to its authorized representative consistent with its security program. The receipt was acknowledged by a properly credentialed employee, but the agent designated employee of the sister company didn't have the authorization to handle the transport. In other words, it went to another party who was not authorized. They didn't have an STA in place to handle it. Well, we were able to negotiate it down to $6,000, which is great, just about a third of what the claim initially came out as. And we filed the petition. We had an informal conference, and we had some discussions. And all they had the premium paid for the fees. So it went really well for them because they didn't have to incur what would have been probably 3 times as much in legal fees compared to the premium.
We've got 10 more minutes left, Lenny, a little bit less than that. Do you want to run through these cases?
Thank you. Let me run through it. Here's one, $22,000, went down to half, $11,000. And this was one where the CCF didn't screen, as I had mentioned, and their ETD, their explosive trace detection, showed that failed, that they just didn't screen it. Again, we were able to take this down by 50%. The legal fees weren't paid because the premium was in place. They paid it for regulatory defense. And then the third one we could jump to was the FAA, which was in place much longer, of course, than before the TSA. And they're still out there with hazmat claims. They said that there wasn't hazmat training. We were able to discuss it with the special agent. The training was conducted, and we showed the certificate of training. FAA said, thank you very much, no claim. And when I say no claim, no fines. So we got it down from $32,500 to $0, again, through the regulatory defense program.
Yeah, it's a great contract and well worth it. The last slide we want to address is the risk review program. And the importance of having your paperwork reviewed by an attorney. This program provides you with that opportunity. It's offered through Roanoke, and it addresses upfront legal concerns such as proper documentation, regulatory compliance, operational exposures. One of the good things is it's an insight into your operations, because no two operations necessarily run the same. It analyzes and reviews your business activities, reviews your terms and conditions of service, of carriage, warehouse receipt, and it's access to pertinent materials documents. So oftentimes, attorneys can get you access to places you wouldn't really have access to. We do have a few questions, Lenny, that you could probably help us with.
And I just wanted to say, again, thank you to everyone for joining. We are going to take a few minutes and answer questions in case you hang on for a few more, or if you need to jump off. Just remember that there is a survey that's going to be launched, so please take a few minutes, just 2 or 3 questions to give us insight as to your thoughts about the webinar and what are the things we can help you with in the future. I know there were a lot of good takeaways from today, and we do hope that you take a few minutes now and put in your questions if you haven't already done so. So go ahead, Karen.
About including a link of the terms and conditions in the email signature line for all staff. Do you think it should be limited to certain people, or should everybody have their signature line?
It's a bad idea. It really depends how big is your company as well, as to then who is going to have that link. If the link is fresh, if it's kept up to date, I don't necessarily see a problem. At the very least, please keep it on your website so it's there. If you want to put it in your signature block, I don't necessarily have a problem with it. I wouldn't necessarily see a downside of it as long as the link is fresh and it truly is accurate. That's the only thing. Make sure you could manage that appropriately and that it is disseminated by folks that you're comfortable will be to provide that information on an updated basis. And I think if it's electronic, you should be able to do that.
Plenty. Another question, would it be considered negligent selection of a carrier if the carrier is transporting goods that are more than the carrier's motor truck cargo limit? That's a good
Yeah, one. Negligent selection, well, what went wrong? I'm going to look at the damages. I'm going to look at whether the cargo didn't make it, it was misdelivered, there was some problem with it. If you are, in fact, choose a carrier who is a reputable carrier, but you ended up choosing a carrier who was transporting goods valued at more than the carrier's motor truck cargo limit, yes, I am going to see that as negligence on your part, a negligent selection of a carrier, possibly. On the other hand, it really could also be negligence in how you operate as well, just in a general sense. But yes, I think that could be negligent selection, but I'm going to go back and say, well, vetting process did you go through? Maybe they were a good carrier, however, you didn't necessarily look at the value of that really was your own negligence as opposed to the selection of the carrier. I could see it coming about in a few ways.
Okay, one of the questions is talking about, bill of lading. We talked terms and conditions and how you meant liability on a bill of lading. What about the delivery order? Are they okay if they include language that they're not responsible for selection of the carrier if they require their clients to select the carrier?
I understand that there is a concern with the bill of lading. That is not, I would agree, that is not the limitation. We're going to look at all the paperwork, all the documents between the parties, which shows the meeting of the minds. So if you include language in that delivery order and it's clear that this is the understanding and that they've seen that delivery order and they're aware of it, I'm going to say that I think that's going to be very helpful in allowing us to defend you because it's going to show a meeting of the minds by way of that delivery order. So yes, go look beyond the bill of lading. The bill of lading is so critical, but if there's other information that really is pertinent to that transaction and the understanding of the parties, yes, that's something we're going to want to look at and use to defend you.
Okay, thanks. I think that's correctly. The question was, I understand that we can be held liable from wrong GMs. If we have a supplier, shippers send us EGM, then they'd be responsible for the correct information. So that's a question, I guess. And if a typo or transpose a number, then it would fall under for clerical error. I think they're looking for some clarification on that.
Yes, I think that was well stated, actually. I think that's a combination question and comment, and I generally agree with it. You can be, my understanding is, yes, you can be held liable for the VGMs. That became an issue when the SOLAS was amended to include the VGMs, of course, as well. And that's the verified gross mass, by the way, which became a big issue in the ocean industry. If your suppliers or shippers send you it, they should be sending you the correct information. You could have a defense if they don't send you the correct information. But then if you transcribe it or provide it wrong, could that be a clerical error of some sort? Sure, we would want to try to argue that it wasn't negligence, but it was actual clerical error, and your E&O should cover that if there ever was an issue for that. Again, because this is a legal regulatory requirement, regulatory defense might help here as well. That if the government came against you and said, well, you provided this improperly and there was ever a claim against you for it as well, then that's where the regulatory defense would kick in. So you want to think about E&O as well as regulatory defense in this scenario.
So I have just one more minute here, Lenny. I just wanted to ask you and Karen just for one or two key takeaways for them today from the things that you went over. You had several issues and gave several points. So if you had one or two things you wanted to mention as we close.
for takeaway, because I see this all the time, every day, are your terms and conditions, the documentation that you issue is important. Knowing who you are and what you're acting as, and terms and conditions that reflect those activities are vital to your business.
I would echo that as well. Really, we're going to look at your documentation, your paperwork that's generated in these transactions, your terms of condition, airway bills, bills of lading, delivery orders, warehouse receipts. All of that is really critical. Scrub those down, see what they look like. Look at the invoices and the services that you're providing, that you're representing yourself out to provide as a service, and what your website looks like. If it says that you're doing certain things and creating an understanding of services that really aren't within your wheelhouse, reconsider whether you should be providing those services, and get those of liability and all of those documents I mentioned so we can protect you, especially for E&O. And if you don't have regulatory defense, get it today so we could save you thousands of dollars if, unfortunately, there ever is a claim.
Fantastic. Great information, Karen and Lenny. Good presentation. Thank you all for joining us today. And you will receive the link with the recording and the presentation very soon.